Yes, Your Honor. Thank you. Daniel Hammond, Assistant Attorney General for the Division of Insurance. Your Honors, in Massachusetts, there are two distinct statutes of limitations that govern civil actions brought under penal statutes. The first is Chapter 260, Section 5. That's kind of the general statute. It creates and it is a statute of repose, and I'll explain what I mean by that in a moment. Under Section 5, there is a one-year statute of limitations for actions brought seeking penalties or forfeitures under a penal statute. The limitation expands to 2 years if that action is brought by a governmental agency. And notably for our purposes, Section 5 speaks to 1 or 2 years after the date of the offense committed. Now, that's significant because the second statute governing civil actions under penal statutes in Massachusetts is Section 5A. The two statutes were both adopted in 1975. Section 5A governs specifically any action brought under a statute designed to protect consumers. And given that restriction, it could not be more broad. Insofar as the statute goes on to say it governs any action brought, first of all, by any person, including the Attorney General, presumptively also meaning any other governmental enforcement agency. But it also speaks to any action for fines, for damages, for penalties, or any other relief. So our view is that the legislature, in adopting 5A, intended that to apply as broadly as possible within the consumer protection sphere.
So your point is the first part of it, with its broad language, means it covers this.
Yes.
And the last sentence about whether for damages, penalties, or other relief means that the appeals court reading is incorrect because you can't sort of carve out penalties and treat them differently as far as the
discovery rule.
Yes. I'm sorry.
As far as the discovery rule is concerned.
Yes, as far as the discovery rule, exactly. And just to complete the exegesis of the statute, the 5A then goes on to say it's a larger period. It's a 4-year period, and it speaks to from the date that the cause of action accrues. Now,
is there any other statute which permits a penalty which speaks of a cause of action accruing? I mean, it's not the usual term with regard to an agency action.
Well, it's not in the sense that outside of the consumer protection sphere, I think you would revert back to Section 5. And Section 5 does speak to the date from the date of the offense.
Which is the more typical with regard to a criminal matter or even a civil.
I think it's almost universal in the criminal sphere. And in most civil penal cases, 5 obtains unless, and we would say the legislature made a judgment that where consumer protection is at issue, it should be extended at least until such time that there is an awareness that a consumer protection violation has occurred.
If this were not the insurance, but it's actually the Attorney General enforcing under 93A.
Yes.
Is there and you can, the Attorney General can impose civil fines, yes?
Yes.
Okay.
Under 93A, Section 4, yes.
Right. So is there a discovery rule in that?
There's never been a specific holding by this court either way. What there has been, there's always been an assumption that the Attorney General can, and in fact, empirically makes use of the discovery rule with some regularity.
With respect to penalties as well.
With respect to penalties as well. And just as a practical matter, a lot of 93A actions brought by the Attorney General or 17060 actions brought by the Commissioner combine the forms of relief sought. Very frequently, there is an underlying offense charged, and the relief sought is, first of all, an injunction, stop the action, restitution or damages, meaning make the consumer whole, and then penalties, forfeitures, et cetera, more punitive damages. They're often brought in the same complaint, often in the same count. And traditionally, it's always been assumed, at least, that a discovery rule attached in that scenario. The only time this court has construed Section 5A vis-a-vis the discovery rule was the Lambert case in 2007. It's a 93 action. It's not brought by the government. It's a private action brought by an individual against Fleet Bank. But there, this court said pretty unequivocally that the cause of action does not accrue, and that's the terminology under 5A, until the plaintiff knew or should have known of the damage. So that's the backdrop. That was kind of what we would argue was the settled rule in Massachusetts until this case came up through the administrative stage, and frankly, until it hit the appeals court. Now, as we note in the briefs, this was a bit of a curveball thrown to everyone by the appeals court in the sense that neither party argued the applicability of the discovery rule to the appeals court. There were issues about statute of limitations that were litigated there. There was a threshold battle over whether Section 5 or Section 5A properly attached to this cause of action. The appeals court decided that unequivocally in favor of 5A applying because this is a consumer protection statute. Two consumer protection statutes, actually, that were the subject of the underlying prosecution. One is Chapter 176D, Section 2, which is listed specifically in 5A as one of the consumer protection statutes that it applies to. The other is Chapter 175, Section 177. That is the statute that specifically forbids the payment of a commission by an insurance company or agency to an unlicensed person, which is precisely what happened here. Section 177 is not specifically listed in 5A, which was why this was an issue at all, but 5A says, 5A sets out a very long laundry list of consumer protection statutes to which it applies. But before that, it says that the following list includes but shall not be limited to. So it's clearly not meant to be an exhaustive list, and the appeals court had very little problem saying that, yes, 175, 177 is a consumer protection statute and therefore should be covered by 5A.
Now, if you prevail on this argument, would this matter have to go back for a finding as to whether or not the matter was discovered in 1999, which I think was the claim before the appeals court?
Well, the appeals court found that, thank you for flagging that. That is the other statute of limitations issue that was joined at the appeals court. Anawan claimed that the division received anonymous written complaints as far back as 1999 saying something's going on with Anawan. They have a second agency that's in violation of a moratorium that the division had set up with respect to the second agencies. The appeals court rejected that argument and said that no, the division was not in any meaningful sense on notice until, and let me just play that out a little bit.
But is that now dicta if you're right? Because that was not the basis for their decision.
But the hearing examiner surely found that.
Yeah.
Yes, the
They
presiding
were not
officer,
on notice until much later.
the presiding officer found that. The appeals court affirmed that. And if we are right that the discovery rule attaches, then yes, clearly there is a factual issue as to when did the clock start, when was the division on notice.
But isn't Justice Cordy saying that take the appeals court out of this equation?
Yes.
Hasn't that been established?
It has. I'm sorry. Yes, Your Honor.
By
it
the
has.
hearing examiner.
Yes.
And on appeal, are you saying that the appeals court decision on that is dispositive, or that we should be revisiting it if we find that to be dicta?
That's an interesting question, Your Honor.
Don't we look back to the Superior Court?
Yes. My understanding is the premise of FAR is that the appeals court decision is now essentially a nullity, and therefore, yes, I suppose that is a live issue.
So we'd have to review the Superior Court decision as to that.
Yeah,
in the same
right.
way.
Which
Okay.
in turn affirmed the
With regard
finding
to
of the
30
presiding
years.
officer. So yes, that issue would be queued up in front of you. And if you'd like, I can walk through at least the rationale for that decision. Factually, what happened here was, as you said, in 1999, the division received written complaints about Anawan. But what's notable is the offense charged was actually something different. The offense charged was they have a second office. You're not supposed to have a second office. Here's where it is. It's in Revere. So the division, upon receipt of the complaint, sent an investigator out. The investigator, in fact, found that there is an individual holding himself out as a producer, doing business at the address in Revere that was referenced in the letter. He has, so they got his name. This is Mr. Prum. He is not expressly holding himself out as a representative of Anawan. Instead, he purports to be operating as a Handle Insurance Agency in Revere. So the investigator then goes back and ascertains that no, in fact, Mr. Prum is not a licensed producer. He was at one time. His license has now expired. So there is an individual there who is an unlicensed producer who is, in fact, soliciting business. He's operating under a DBA that's not on the division's radar anywhere. The Handle Insurance Agency is not a license holder. It's not a known entity. And then he kind of hits a stone wall for a while. He's clear that, and one thing that should come out here is there is no express statutory sanctioning authority that the division has over an unlicensed individual. The power of the division is as against licensees. So the investigation kind of hits a brick wall for a while. Then later, over a year later, over 2 years later, actually, I believe, the investigator starts working the same complaint back from the other side. He goes to Anawan and says, Anawan, well, basically, it starts to draw the connection. We got a complaint
Okay, so
about...
you said the clock starts as soon as you learn that Anawan indeed had retained or had been using it.
Yes, that's the key link.
That's when the clock starts.
That's the key link.
Okay.
As far back as 99, there was knowledge that something untoward was going on in Revere.
But if
It
the
wasn't-
clock, if the clock starts in October of 2000, then all of these things are within.
That's correct.
So it
That's
doesn't,
correct.
they don't have to go to 2002 or whatever.
No, not at all. And yes, the point is it was not until well after October of 2000 that the division linked the two.
Go ahead.
Going to the second argument with regard to 177, the violation here was $100 per violation.
Yes, correct.
Could
Yes.
that have been imposed under Section 177 or not?
Our view is that it could, although there's no construing case law out there that says that. And frankly, there's no division finding on that because the division proceeded under 176D. The appeals court obviously flagged that in a footnote and said it's not clear from the language that is anything other. Well, it expresses no opinion. It goes out of its way to say it expresses no opinion, but it flags the issue. It says 176D clearly speaks in terms of here's the dollar range that you can apply as to each violation. 175, Section 177 just gives you a range and does not specifically say per violation. As a practical matter, it's the position of the division that that's all that can mean, because otherwise it invites, essentially it invites, if it's a one-time offense, then it's not a disincentive at all. It's a very minimal cost of doing business. It in fact, incentivizes its own violation. If it also invites an interpretation by the regulator that, okay, then the only thing to do is to prosecute each violation as a separate case. That's kind of an absurd result. So the division's position is that, yes, absolutely, it could have imposed the $100 per offense penalty under either of the two statutes. But our most prominent argument, obviously, in the brief is that the appeals court got it wrong when it said you couldn't prosecute both concurrently. And the reason for that, the primary reason for that is Section 12 of 176D, which says as plainly as it's possible to say it, the sanctions under this chapter are additional to any other sanctions that are available under any other statute.
Can I ask you a slightly different question?
Certainly.
Really, the violations of 176D, are they essentially premised on the violations of 177, of 175, Section 177?
They are, yes.
All right. So because he violated Section 177,
Yes.
the hearing officer found that he violated 176D?
Yes,
Well,
that is correct.
176D seems to, it really is it's the kind of conduct that smacks of intentional knowing conduct. Someone engaging in a deceptive practice, an unfair practice. I take it at this point in time, the conduct couldn't be punished under 177
That is,
because it wasn't a knowing
that
violation.
is correct. The 2002 scienter requirement would have, if it were to happen today, you're correct.
So they could,
Yes.
you couldn't do a 176D because you wouldn't have a 177 underlying offense.
Well, you clearly
Violation.
couldn't do the 177 because, or at least you would have had to make out a knowing violation in order to proceed there. Our position is that it would really be up to the presiding officer to determine whether this was unfair and deceptive.
So your
in its
position
nature.
is that an unknowing violation of 177, which wouldn't be a violation, might still be a violation of 176D, an unfair trade practice?
It could. It would be fact-specific. It would be up to the presiding officer to determine.
I mean, it seems a little odd that an unknowing violation, in other words, you simply didn't know that this person's license had expired and they hadn't renewed, is an unfair trade practice or a deceptive trade practice. I mean, that just seems a little odd.
Well, I think the rejoinder to that, Your Honor, would be the standard that I would expect the presiding officer to apply there would be knew or should have known. And that's where the facts of this case come in. And admittedly, it's at the margin. But Anawan, on the record, was aware of, it did do the due diligence up front. It found out that
Yeah.
Mr. Prum was licensed. But in getting a faxed copy of its license, it also knew the expiration date of that license. And therefore, arguably was on notice that on that date, he ceases to become licensed unless he renews. That puts some obligation on Anawan to continue forward with further diligence to make sure that, yes, in fact, he renewed, or if his license expired, that he went through the processing and got licensed again. Anawan did not do that here. If under the situation you're hypothesizing,
And so that's an unfair
They went-
trade practice.
well, that would be the question that the presiding officer would have to decide if it were brought into the universe where a knowing violation was required.
Okay.
Thank you, Mr. Hammond.
Thank you, Your Honor.
Mr. Michaels?
Please the court, Stephen Michaels for Anawan Insurance and Pro Se. The real underlying statute here and the findings of the presiding officer, I think, make this case more or less obvious and open. Presiding officer at the Division of Insurance found that Anawan violated General Laws Chapter 175, Section 177, when it failed to ascertain that Mr. Prum had not renewed his license in May of 1997. There's only one major problem with that. He also agreed and found that the Division of Insurance did not even cancel Mr. Prum's license until November of 1998, nearly 18 months after. We live in an automated age. People go online, check things. There's no evidence taken one way or the other relative to what Anawan did or did not do, but the facts speak for themselves. If Anawan had, in fact, gone to the Division of Insurance on June 1st, 2007, Mr. Prum would be shown as an active person. As of January 1, 1998, his license would have shown as active. So the division is seeking to impose a duty upon Anawan, because that's the finding of violation, that A, it could not possibly perform as of the date of license expiration, and it would certainly be an unreasonable duty for any business in the Commonwealth to be required to do. In my brief, I cite the case of Viglianti, where it deals with...
Explain to me, why is it unreasonable to require an insurance agency to ensure on an annual basis that the agents that are writing insurance under its name are have maintained their license?
Well, there's two things. If, in fact, the legislature felt that that was an appropriate way to deal things and to run the business, that would be fine. But the Division of Insurance, for instance, in this case, let me make this very, very clear. The broker relationship that existed here is an independent party. This person is not an employee. In fact, if he were, that's not at all an issue. So there's no direction and control that the agent would have with people who they may pay compensation. It's certainly reasonable and fair to say when that relationship begins, you should be certain that they're licensed. And that is something that can be ascertained through public record, copies of licenses, all of which was done here. The issue here is whether or not then the insurance agency should be required to monitor the conduct of independent parties who have their own relationship with the Division of Insurance. As part of the overall record, the Division of Insurance in 2001, dealing with Internet practices, was stated blatantly that it is the responsibility of the unlicensed agent to comply with the laws. So they more or less did go on record saying, hey, we're not looking at you to do it. Here, with relative to the 177 violation, the finding of violation in itself is completely illogical. Because had ANOAN made reasonable efforts, and I would trust that Your Honors would find that checking on the Internet or maybe making a phone call to the division to find out whether a person is still licensed might be an adequate and sufficient way of checking on it. Again, not never.
Wouldn't it be a more adequate way, and probably to check with the putative licensee himself?
In terms of,
Like, can we see
that
the
is
license?
that is one way that you could do it, but if you call the putative licensee, and this is a very unique situation, the putative licensee is up and operating day to day with a business location named Handle Insurance. All you would get from the putative licensee is, yes, I renewed. That would be a verbal thing that you couldn't even confirm you have done that.
Well, explain to me again if ANOAN had contacted the Division of Insurance annually, January 1st of every year, January 1, 2000.
Well, the licenses are not annual in nature. They run for 3 years.
Okay, but where the violations were found to have occurred in 2000, right? All the violations were during the year.
No,
Oh,
that's not correct.
went back to 98. That's part of what the appeals
This
court.
goes,
Yeah.
actually, what I would say is...
Wait. Hold on. 278 violations between November 1st, 2000 and December 31st, 2000?
But weren't there some that went back before that?
And 22 violations between August 1, 2000 and October 31st, 2000. I thought those were the violations.
Again, the Division of Insurance, in all deference, its order makes no sense, Your Honor. They made findings based on policies.
I just want, but the violations were found during the year 2000. Am I wrong?
No, they began to count forward until the relationship between ANOAN and the broker finally ended and concluded in 2001.
The payments, the illegal payments, were made when?
They were made in 2000 and 2001, according to the division.
Right, and that's the violation. It's making the payment.
That's not what the presiding officer said. The presiding officer said the violation, his decision, was when we failed to ascertain it. Because it has to be a knowing violation of 175, 177. In other words...
No, it doesn't. It didn't back then.
When this matter was
It didn't
brought,
back then.
the legislature had clarified the statute. It was silent prior to 2003.
It was brought under the statute as it existed
as
in
it
2000.
existed back then, but quite frankly, Your Honor, I think in all deference, I believe the legislature clarified itself well in advance of this action being maintained.
All right. Well, I'm now confused. I thought the payments that were deemed as violations because you were, I take it, fined per violation.
And again, that is not in the statute. But if you don't mind, Your Honor, I'd also like to address the statute of limitations issues.
Sure.
One, of course, 265 deals specifically with penal statutes. There's case law on the point. A penal statute is a fine or forfeiture in favor of the Commonwealth, and it is very clear and specific that it would be within 2 years of the offense last being committed. Here, the last offense by agreement of all parties was at the very end of 2001. Action was commenced in October 2004. If, as the appeals court suggests, this were a consumer-related statute, a 4-year statute of limitations would in fact apply based on when the cause of action accrues. Your Honors, I'd suggest the cause of action accrues with the state legislative agency when it receives a complaint naming the party whom they're going to investigate. I think it would be a disservice to the public and businesses in general if our administrative agencies were able to sit on things for untold years without taking any action and not even notifying the party against whom the complaint is lodged.
But that doesn't go to, I mean, that may, in a particular case, you might find some equivalent of latches, but that's a different issue.
Well, the statute of limitations in terms of 5A says that the actual case cannot be brought unless it is brought within 4 years of the date the cause of action accrues.
Right.
And so the question is, when did the division have this cause of action accrue?
Right.
And the argument that I am making is the cause of action accrued on actually one of 2 dates, both of which are in the decision and order of the division. They either accrued in October of 1999 when it had received 2 complaints, specifically naming the Anawan Insurance Agency as the party to be investigated. It certainly accrued in 2000 when, in September of 2000, the division's investigator, who was the only party presenting testimony at the hearing, went to Handle Agency and was found that there was nobody licensed there. It would be unrealistic to say, I am investigating a complaint about Anawan, I go to an agency that has a name insurance agency, and I then make an investigation, determine there's nobody licensed, and then proceed to do nothing for 4 years. Now, there the cause of action accrued. I mean, that's would just be logical counting. What the division's arguing, and this would be, would basically be that any administrative agency can turn around and basically say, we can take in a complaint, we can sit on it for literally ever, and when we get to it and we find enough and proceed, that statute of limitation just never stopped running. And what I'm contending is when the complaint comes in, it's an obligation and not an unreasonable obligation on the part of the administrative agency to initiate the investigation then, including at least contact the party name. Again, the complaint came in 1999. Anawan was not even contacted until 2004. So what I believe the Division of Insurance is trying to do is ignore all our dithering here. Now, the issue of damages, I think, is well in excess of the statute. I also believe that the 176D does not provide for any penalties to be levied under it. The division cites Section 7, and Section 7 basically provides for penalties for violations only of 3 and 4. If you read Section 7 of 176D, you will find that the penalty provisions specifically apply only to Sections 3 and 4 of 176D. Section 4 deals with loan transactions, and it's not material to here. And Section 3 makes one mention of 175, but not the statute that is in question here. And the 175 statute references a discrimination statute with no penalties. So what I'm suggesting is what the division is attempting to do is to piggyback onto a statute, find a penalty provision in that statute which does not in any way apply to 175, 177 violations, and say we can now start assessing penalties ad infinitum. That, in effect, would mean that every statute referenced in 176D2, to the extent it contains a penalty provision, becomes irrelevant. Because the penalty provisions, I mean, the division could turn around and say, we choose to ignore that and we're going to go with our own penalties under 175.7. But I think if you read the statute, Your Honor, you'll conclude that the legislature carved out only 2 sections of the statute for those penalty provisions.
So you're saying that there is no penalty provision in 276D, Section 2?
And not for a violation of 175, 177.
Not for a violation of 177?
That's what I'm saying.
What about 176.12? The powers vested in the Commissioner by this chapter shall be additional to any other powers to enforce any penalties, fines, or forfeitures authorized by law.
It's an additional statute, and quite frankly, what the Commissioner could do, for instance, is enjoin a violation of 175, 177. And if, in fact, the party so enjoined violated that injunction, there are provisions within the statute for violations of knowing violations of injunctions and whatever. But 176D, Section 7, which the division relies on, is not that type of provision. So the key things, Your Honor, is you have a situation where all an insurance agency did is it operated a business. It fully cooperated within 3 weeks with the Division of Insurance request for information, and based solely on its cooperative response to that request, the Division of Insurance sought to levy a $30,000 plus fine on a cooperative business. I would offer this, Your Honor, if that is the way the Division of Insurance is permitted to act, who would cooperate with them? And in fact, if that is the way an administrative agency is permitted to act, who would cooperate with the earnest, good faith requests made by administrative agencies to every business in the Commonwealth every day? There would be no reason to do so. In fact, everybody would effectively ask their attorneys to get waivers, and I mean, commerce in this Commonwealth would be a mess. And that's exactly what the division did here. There was no ongoing violations. In fact, these actions had ended in 2001. They bring an action in 2004. They claim, well, we didn't know about it until you cooperated with us and told us what your relationship was with this person, even though they could have known that as soon as 1999 and certainly should have known that in 2000 when they went out and found a bunch of unlicensed individuals. Instead, what the division went out and did is let this unlicensed agency, by its own admission, operate for multiple years, and for all I know, it's still operating with nobody who's licensed. That, Your Honors, makes absolutely no sense. And this was the type of case where I think the facts were not disagreed with. What I think is the analysis made by the hearing officer was extraordinarily flawed. The penalties exceed any statutory remedy. And thank you, Your Honor.
Thank you.